dictation starts, we may point out that the appellants never challenged subsequent visits and searches of their premises by the respondents on the ground that, in the absence of a fresh authorization, those searches were illegal, null, and void. Notwithstanding the same, it was argued that, at least for the purpose of limitation, the subsequent searches could not be taken into consideration, as, according to the learned counsel, the legal position was that the authorization dated 19 June 1998 was executed on 22nd June 1998, and the search came to an end with that when the search party left the premises on 23rd June 1998. After making seizure of certain documents, etc., and issuing a restraint order under section 132 in bracket 3 of the Act in respect of certain items which they allegedly could not seize due to impracticability on that day. Some judgments of various high courts were relied upon to support this proposition. It was also argued that there was no concept of revalidation of authorization provided under the Act, which has been applied by the High Court in the impugned judgment, which, according to the learned counsel for the appellants, amounts to legislating a new concept which is contrary to law. Para. The learned additional solicitor general, refuting the aforesaid contention, submitted that, as per explanation in bracket 2 to section 158BE, when it is a case of search, period of limitation is to be counted on the conclusion of search as recorded in the last Panchanama drawn. It was argued that last Panchanama was admittedly drawn on 5th August 1998, and therefore period of limitation is to be counted from that date. Para. After considering the respective submission, we are of the opinion that on the facts of this case, the issue also has to be answered in favor of revenue without going into the legal niceties. Para. As noticed above, the revenue authorities visited and searched the premises of the appellants for the first time on 22nd June 1998. In the Panchanama drawn on that date, it was remarked temporarily concluded, meaning thereby, according to the revenue authorities, search had not been concluded. For this reason, the respondent authorities visited many times on subsequent occasions, and every time Panchanama was drawn with the same remarks, that is temporary. Over. Thank you.